Was a busy week for the Apex Court this week as it delivered 2 judgments on closely watched cases. The highest court in the land overturned the Supreme Court of Appeal's ruling that former President Jacob Zuma's medical parole was unlawful and has since referred the decision to the Department of Correctional Services to determine whether the former president must return to jail. The department has said it is currently seeking legal counsel in the matter, and in other matters this week, the court then ruled that Busisiwe Mkhwebane's suspension was indeed rational. We take a look at these legal developments with legal analyst Benedict Phiri. Benedict, thank you very much for your time this morning. Let's start with the Jacob Zuma matter. How should we understand the order?
Well, what we should understand from the Constitutional Court is it refused to entertain an application by Correctional Services to appeal the order of the Supreme Court of Appeal, which declared, or at least upheld, that Arthur Fraser's decision to release Mr. Zuma on medical parole was unlawful. If you read paragraph 60 of the Supreme Court of Appeal judgment, which is actually the operative judgment at this point in time, the court didn't mince its words about what is actually the current situation at law. It said that in law, Mr. Zuma hasn't finished his sentence and he should go back to Escort Correctional Facility to do so. And to the extent that the commissioner may want to consider, taking into account the period of his incarceration and the period he's been out, in the computation of the entire period, the commissioner may do so if he is empowered to do so. But, it was quite clear that, the legal consequence of the decision at the Constitutional Court yesterday is that Mr. Zuma should return to Escort Correctional Facility to complete his sentence until the commissioner has satisfied himself that he has a power to release him early.
Since the news broke, we have been hearing from some sectors of society saying, well, the former president did not open the locks or the keys to the door that let him out of the prison gates. And so what should we understand also about that aspect of it? What then does the acting commissioner, or what role will he have to play?
And I think you're correct, because there is an element where we do have to be fair to the former president. But, his coming into his current situation did come across as an unlawful, as a result of an unlawful act. And you've got to firstly address the unlawful act and at least deal with the fact that, we've created the right consequence from a legal perspective. And then the commissioner, I think, can then, if he is empowered to do so, if he does have grounds under the Correctional Services Act or any other piece of legislation or law, consider all of these factors in coming to a decision, should he be so inclined to keep Mr. Zuma out of incarceration. But I think first and foremost, as a matter of following through with dealing with the unlawfulness, I think we've got to rectify the unlawfulness, and that means that at least even for a day or a minute or however how long it might take, Mr. Zuma must present himself to the Escort Correctional Facility, and then the commissioner can take whatever lawful means are open to him, and should he be inclined to do so, and take into account some of the factors that you've raised, including the fact that he's not the one that opened the prison gate for himself. But I think first and foremost, we should see Mr. Zuma at the Escort Correctional Facility, and then the commissioner can do what he may be empowered in law to do after that.
And then let's get into the public protector as well, the suspended public protector advocate Busisiwe Mkhwebane. When it comes to the court's decision, was it a sound legal decision?
It was a sound legal decision. I think it was very clear, the way the court viewed it, that you couldn't isolate the president's risk of a conflict of interest or bias to just the fact that he'd been sent the questions on para. What the court did was it set out in quite great detail the full timeline in respect of the events that eventually led to Busisiwe Mkhwebane's suspension. And effectively the court said, this suspension was coming for a really long time. And if anything, the president, didn't act in his best interest by taking so long, and should have probably done the suspension a lot sooner. So when you look at it from that perspective, you couldn't say that the president was conflicted when he was taking the decision, because the decision had been under consideration on other factors, on a number of factors, in fact, that had nothing to do with Para for a very long time. So I think that was a sound decision, and I think, you can also imagine the mischief if someone like a public protector or any of those democracy-supporting institutions in our Constitution is facing a suspension. They may just, raise a dispute for the simple fact of just not being able to give effect to the president's powers at that point in time. And I think the court was alert to that potential mischief.
So the judgment, or at least the summary for the post-judgment media summary, as found on the Constitutional Court's website, reads, on the facts of the present matter, the court held that the mere fact that the public protector is investigating the president cannot create a reasonable apprehension of bias or expose him to a risk of conflict between his official responsibilities and private interests, as you have just mentioned. It also outlines some of the timelines. On the 7th of June, on the 3rd of June, let's start there, the Office of the Public Protector received a complaint from the ATM. On the 7th of June, the Public Protector wrote a letter to the President instructing him to answer 31 questions. On the 9th of June, the President suspended the Public Protector, and the Deputy Public Protector took over the functions of the Public Protector. And so when we speak of being exposed to bias or risk of conflict of interest, what should we read into that, if anything, especially in terms of the timelines?
And I think the timelines are important because, effectively the impeachment of the Public Protector or removal from office is a process that belongs to Parliament. And I think that's an important consideration to put at the back of this, to say even though the President had suspended her, he had nothing to gain from the process, because it's Parliament that would effectively see to her removal. And I think an important aspect that you mentioned as well is that the acting Public Protector took over office. She filed an affidavit in the matter, which basically confirmed that nothing had been hindered or impeded by her taking over, and that the investigation was proceeding. And in that respect, it was out of the President's hands. There's nothing he could gain from suspending the Public Protector in respect of Para, because first, it's a parliamentary process, and secondly, as far as the acting Public Protector was concerned, the matter was progressing according to prescripts. So I think that's what we can gain, in the ruling, to say, well, if that's the case, if this is a parliamentary process and the investigation proceeds, notwithstanding the suspension, then it's hard to see that there could be a conflict of interest in that particular aspect, or a reasonable apprehension of bias, because it has no effect on the President whatsoever.
Benedict, I do appreciate that you are neither a political analyst or expert or a perceptions analyst or expert, but I would like for us maybe to take a look at the reactions since the news of both these cases on the part of the former president. What has been your reading of the perception that has been created when we take a look at the court of public opinion, as well as on the suspended Public Protector?
If I start with the former president, I think the statement by his foundation was unfortunate, effectively to say he won't be going to jail. I think that's very unfortunate. If you look at, the judgment of the SCA and what the lawful position is, I think that would be the right outcome. And, I think it really is frustrating that even after all these court processes, we still have a former president that doesn't want to subject himself to the rule of law, or at least that's what it looks like from the statements that are given by his foundation. I think with Busisiwe Mkhwebane, I think it's important that the court has weighed in on an important question of what can the president do and not do when heads of these Chapter 9 institutions that support democracy have acted in a manner that Busisiwe Mkhwebane has acted, as elaborated in many court judgments and other aspects. And I think that, from a public perceptions perspective, I think it's great for our democracy that you can have, in this particular instance, two arms of government effectively giving effect to the Constitution in a way that supports our democracy.
Benedict, before we let you go, are we indeed all equal before the law?
I would certainly say that these two court cases illustrate that. Certainly the Constitutional Court outcome for Mr. Zuma, as well as the Supreme Court of Appeal judgment, are very clear indicators that no one is above the law and the rule of law is supreme in this country. And I would say the same with Busisiwe Mkhwebane. I think, the Constitution has been upheld in a very beautiful way by the Constitutional Court, and very clearly showing that we are all actually equal before the law. I understand that practically, or sometimes it doesn't feel like that, but certainly the tone of these judgments point to that we are actually all equal in the eyes of the law.
Benedict Phiri is a legal analyst. Thank you very much for your time.